Hello everyone. In today's video, I'll be discussing about cultural and educational rights, which is Article 29 and 30. So let's start with the discussion. Article 29 talks about protection of interests of minorities, and Article 30 talks about rights of minorities to establish and administer educational institutions. Under Article 29, any section of citizens, that is, both the majority and the minority residing in India, who are of distinct language, script, or cultural interests, have the right to conserve the same. This right is available to every citizen of India, irrespective of majority or minority, but it should have distinct language, culture, or script. Then such majority and minority have the right to conserve the same. The method of such conservation is not mentioned under Article 29. Then any method which is not against the constitutional principles can be used for the conservation. The marginal reading of Article 29 talks about the protection of interests of minorities. However, it would have been illogical if the right to conserve script, language, or culture was granted only to the minorities, and therefore the main operative provision of Article 29 does not use the word minority. Thus, the right guaranteed by Article 29 Clause 1 is available to both the minority as well as the majority section of India. So, Article 29 gives the purpose, that is, the purpose to conserve language, script, and culture, but Article nowhere provides the methodology for such conservation and leaves it to the discretion of the sections of citizens to adopt whatever method of conservation suits them. But under no circumstances, such methods may be illegal or unconstitutional. So now a question arises that an educational institution is recognized by the state, but it is not aided. It is not covered under Article 29 Clause 2. So can these institutions discriminate on the grounds of religion, race, caste, or language? The answer to this is no, because that will be this will be against the doctrine of equality and fraternity. Even if any educational institution which is not maintained or aided by the state, it still cannot discriminate on the grounds of religion, race, caste, language, as that would be violative of doctrine of fraternity. So now let's see Article 30, which is for the protection and conservation of religion and language. We already have Article 26 and Article 29 respectively. And in the same statute, there cannot be two provisions having the same purpose. Therefore, protection and conservation of religion and language cannot be the purpose of Article 30. We know this. So, Article 30 does not have any linguistic or religious purpose. Rather, the purpose of Article 30 is to take care of the educational requirements of these linguistic or religious minorities. The minorities have been given the right under Article 30 to establish and administer educational institutions of their choice. This choice here does not mean that they can establish institutions for religious and linguistic education. Rather, these educational institutions will only be the normal secular educational institution. So, if these minorities have the right to establish and administer educational institution of their choice, then they also have the right to get the affiliation of their institution by the concerned university. Thus, the affiliation also becomes the fundamental right under Article 30 itself. So, none of the fundamental right is absolute. We know this. Thus, fundamental right to affiliation is also not absolute, and the state can impose reasonable regulatory conditions as to make the institution an effective vehicle of education. But the conditions have to be very reasonable and not unnecessary interference in the administration of such institution. So we have this case in the case of Unni Krishnan versus State of Andhra Pradesh, which is of 1993. It was held in this case that capitation fees by unaided minority educational institution is allowed and it is constitutional. So after this judgment, the minority institutions started misusing the judgment and started charging unreasonable fees. So questions were raised regarding that, and after several judgment by the smaller benches, there was finally an 11-judge bench constituted in TMA Pi Foundation case of 2022, and in this case it was held that the charging capitation fees and thereby making huge profits under Article 30 Clause 1 is unconstitutional. Fees can be charged, but it cannot be unreasonable. It was held that educational institution can also be established for profit making under Article 19(1)(g). But education is a natural resource and fundamental to a person. Therefore, you cannot be exploitative and you cannot earn unreasonable profits under Article 19(1)(g) as well. It was held that the right under Article 26 Clause A is for religious and charitable purposes, and profit making is not allowed under Article 26 Clause A. So Article 30 Clause 1 is for the welfare of children of religious and linguistic minorities, and therefore profit making is not allowed under Article 30 as well. So through some nominal profit making can be done under Article 30 Clause 1. So Article 19(1)(g) is a fundamental right to carry on trade, business, occupation and profession. And if any institution has to earn profits, then it can be started under Article 19(1)(g). However, it was held that even in Article 19(1)(g), the Constitution does not allow excessive profit making in the field of education. Islamic Academy of Education, we have this case. It is very famous and it is a 2003 judgment. So Islamic Academy of Education versus State of Karnataka. In this case, it was held that the fees to be charged by the minority institution has to be reasonable, and for that purpose, there shall be a regulatory authority which will consist of a retired High Court judge, a chartered accountant, and one representative each of the institution and the government. This regulatory body will determine the quantum of fees. Now, in 2019, in the case of Chandan Das versus State of West Bengal, a school was started by a Punjabi linguistic minority, but they were given education in Hindi. So the question before the court was whether they can give such education in Hindi or not. On this question, the Honorable Supreme Court held that they have not been established. They have not established the school to promote their language, because the purpose of Article 30 is not to promote language but to provide normal secular education. So therefore, they can give education in Hindi as well, in whatever language that suits them. And lastly, we have case of a very recent case, that is 2012 judgment, which is the Society of Unaided Private Schools of Rajasthan versus Union of India. In this case, Right to Free and Compulsory Education Act 2009 was in question. So as per the Act, 25% seats are reserved for economically backward section of the society. So the question before the court was, will it apply to the education institution established under Article 30 or not? So the court held that the law is not applicable to the institution which is established under Article 30, as it would be difficult for them to manage their finances. So here we end with this article. So that's it for today. I hope you find this video helpful. Thank you.